Well, hello everybody. Welcome and thank you for joining us for today's webinar. Let's get straight to it and let's start the webinar. Today's subject is Top Tips for EU Digital Compliance. I take this opportunity to introduce myself. My name is John Worthington. I am CEO here at IBT Partners. I have to say I do love our webinar Wednesdays. It's a learning series. There is so much innovation out there, and all of that, of course, is accompanied by the regulatory environment, and so it is absolutely crucial to keep up to speed. So I always insist in taking part, and I enjoy very much learning from our in-house team and guest experts. So today we have a really great program prepared for you. As I said, there's been some preparation behind this and some logistics, so we're very pleased to bring you lots of useful information and takeaways. We hope that all of this will drive your exports and your European business successfully and, of course, legally. So today, top tips for EU digital compliance, and I have been asked to state that all of the information that is shared here on this webinar, the slides that you're going to see and the discussions, it is for guidance purposes only. If you have specific needs, please do consult a legal expert who understands these issues. But this is all for guidance. And at the end of this webinar, there is a survey. So I will be asking you to guess or tell me who exactly asked me to say that legalistic phrase there. Was it Michelle or was it Stephan? I look forward to hearing your answers. Quickly, before we begin, a little bit of housekeeping. Do know that this webinar is one in a series, all about helping you grow your business internationally, grow globally. If you go to www.ibtpartners.com/resources, you'll see the webinar program stretched out ahead of you. We have some great webinars lined up. This webinar today will be approximately 30 minutes, a brief introduction by myself, and then I will hand over to Susanna. And then Susanna herself will curate the program and introduce and be talking with the two expert legal guests that we have today. We have Michelle Sally from the UK and Stephan Schmidbauer from Germany. Experts on this subject, of course, of top tips for EU digital compliance. Do know that we have 4 polls prepared for you. We'd ask you to participate. You can see the poll band there. I will be triggering the polls and then we ask you to participate, please. There will also, of course, be questions. On your menu bar on the right-hand side of your screen, you can see questions. Please get on board, submit your questions, let us have your questions. We can respond to them. If we do not respond to them today, do know that we will get back to them in the very near future, get back directly. There's a chat box. Use it. Please open it up, press the plus button, chat away, share your information with us and your views. As I said, at the end of this webinar, there will be a brief survey. This will be displayed and we'd ask you for your feedback. And finally, please do know you don't need to take any notes. A copy of this recording and the slide deck will be sent to you on Friday when it has been prepared and curated by our back office here. So, well, there we go. There's the introduction. Let's get started. A quick, brief introduction to IBT Partners. IBT Partners, we're a private company. We're a firm of online engineers and business developers. We have offices in the US, UK, Germany, and France. And for 15 years, we've been successfully providing online international services. Our core activity is helping companies grow their exports and business. And we do that by building international localized websites and then, of course, providing all of the ongoing online marketing services into those target markets. So our core message is all about go global with website localization. And so this sits so very well alongside today's keynote subject, which is top tips for EU digital compliance. Because as we're out there building websites and providing digital marketing, and we do this across the European 28 countries, our main demand tends to be for the UK, Germany, and France, followed by Italy and Spain, but also Scandinavia, of course, and Eastern Europe, Poland, but all of this has to be done with respect to the European regulatory environment. So now I present our host, Susanna. Susanna is Director at IBT Partners for Europe. Susanna was educated and worked and has lived in the US, in New York to be precise, and in Europe, in Germany, the UK and France, and so knows this program and knows the questions of internationalization very well indeed. Michel Sally is a leading intellectual property lawyer who advises on all aspects of intellectual property protection and enforcement. Michel works predominantly with startups, but also mid-sized companies, and is a regular adjudicator for Innovate UK. Stephan Schmidbauer is a qualified lawyer and TÜV certified data protection officer with a wealth of experience in IT and data protection law. And both organizations, that is Briffa and Intersoft Consulting, adhere to Privacy Europe. Privacy Europe is a network of businesses and lawyers founded on facilitating compliance with global laws and regulations regarding data protection. They do have a great website. I do encourage you to take contact with our experts and also go to their websites. That's briffa.com and intersoftconsulting.de, but also do check out privacy-europe.com. It's a great website, and there's lots of information. So finally, the top tips for EU digital compliance. We're going to dive into the changing data protection landscape. We're going to talk about EU-U.S. Privacy Shield and process and management of data and how that will affect your business. So with lots of subjects in mind, I hand over to Susanna, and I thank you again for joining us. Susanna.
Thank you very much, John. Thank you. That was a lovely introduction, and welcome everybody. We're excited, as John was saying, to get down to our subject matter. Just to let you know, sort of a table of contents, I'm going to give a brief introduction to how we see the digital world, in particular for the internet, differences in compliances and what that means for an internet site, and then hand over to Michel, who's going to talk about EU regulations and the US Privacy Shield and some top tips, and then to Stephan, who will be elaborating more on the website compliance issues and again giving his top tips. At the end, as John said, we will have some time for questions, and I would just reiterate what John was saying. You know, this is a live Q&A. Put your questions in the question box. We look forward to answering them. So without further ado, I just wanted to start off really with this slide here. I know there's too many numbers and all that, but it gives you some direction and some scale. There's a lot of numbers out there about the size and impact of the internet on business today. I heard recently, 12% of all business activity, transaction activity, is now on the internet. Someone else told me it was 18%. Whatever the size, we know it's large, we know it's growing. And so I've taken these two images from a McKinsey report that came out in February of this year, which just shows you in terms of cross-border bandwidths, the sort of the motorway of the internet, which is expected to rise by another 9 times in the next couple of years. And you'll note that the largest single motorway bandwidth is really between the EU, Europe, and United States. And in terms of digital flows, it really just says the very similar thing. And again, the mega trend is also between Europe and United States in terms of cross-border bandwidth and global flow of data and communication. And what's interesting now, and McKinsey's point really, is that the digital online side is the net changer, as it were, in terms of global growth. Now, John mentioned that we're experts in sort of what are called localized websites, and I wanted just to sort of show you what is a localized website. A localized website is not a translated website per se. Translation is one item, but localized websites go much deeper than that. They are anchored and fully embedded in a local market. They look and feel like a domestic website, and they interact in that local market. So if you're looking to sell to Finland, it's important not just to have a Finnish translated website, but a website that builds trust and allows the local purchasers or local buyers to interact with you. not just to find you, but to interact with you.
Susanna, could I propose that it's a time to launch our first poll?
Absolutely.
Okay.
That's a great idea.
Okay, well, let me do that then. Please, everybody, this is our first poll. There are 4. This is number 1. I'm going to launch it now. Please do get on board, get ready with your mice to click in here. Do you have localized websites for your export markets? So I guess what that means in this context, do you have a German site for the Germans? Do you have a French site for the French, and et cetera, et cetera? Now, is that yes to all our main export markets? Yes, but only a few. I'll give you some numbers back. 30% yes for all of our main markets, 25% yes, but only a few, 21% are thinking about it, and 30% are saying no. Now, I am about to close this, but before I do, I've got a horn to say this is about to end. There we go. I found that app. That's our hood. This one is going to close this webinar, this poll. Thank you.
Terrific sound effects there, John. Thank you. I just wanted to add, with regard to these localized websites, what is that based on, really? And I guess really it's based on a couple of different premises. The first really is that Google localizes its entity by local market, and not just Google, but all the other search engines, whether you're in China, Russia, or wherever. I mean, Baidu for China equally. So, Google United States is very different from Google UK, even though they're both in English. They're registered differently. They look different. They talk about different things. So it just means that if you're not, if you might be, first top of the heap in Google USA, it does not mean that you're being found easily in the other countries. And this is because, as I said, search engines are country specific. And the third sort of thing I want to leave with you, and in a sense it's also country specific, is social media, which is now such an important business tool, whether we like it or not. And that also is very market specific. Now, getting down to sort of compliance and what that means in terms of the buying process, I want to just sort of leave you with this sort of vague picture of what a buying process could look like for many of you. It involves interrelated aspects of product and price and logistics, and then, if you like, in the middleware of it, types of regulation, whether that's CE mark or health and safety, and in fact data protection, and increasingly data protection. And the point here is that compliance, as well as the product, as well as the price, as well as the service, gives you brand, and that compliance builds your trust, which is so important for the buying process. So digital compliance is one of the main keys, just like technical requirement and technical compliance is a main key to building your brand and making sure that people trust you in the buying process. And with that, I really want to turn over to Michelle now to give us some more specifics on digital compliance and her top tips. Michelle, are you there?
Yes, I am. That's great. Thanks very much, Susanna. That gives us a really great commercial context actually on why we're here, and it might also be useful to give you an overview on how the legal data protection landscape has developed over the last 10 years or so. Certainly from a technical perspective there has been a lot of change, and as you'll see, the law has been really catching up with the technical developments from the outset. So I want you all to cast your mind back to 1995. We had our first EU directive then on data protection. Since that date, the technical landscape has changed fairly dramatically. Google, Facebook, Twitter are now a daily part of our personal and professional lives. We share much more of our information online, and the security of personal information has greatly improved. But the laws haven't really been put in place. If anything, the spotlight has shown how inadequate they were, from Snowden's revelations to the downfall of the Safe Harbour Agreement between the EU and the US. This is something that I'll touch on shortly. So the EU has revisited this position on personal data and delivered a fairly onerous piece of legislation in the form of a regulation. known as the General Data Protection Regulation, or the GDPR. This is a really important distinction between now and back in 1995, where we were given this directive to implement in our own way. We now have a regulation which is directly effective and has immediate impact. As such, the new law is not open to interpretation, and all EU member states must comply. This law even goes one step further in that it essentially applies to all companies that deal with EU-based citizens. So if you're based in the United States, for example, and your customer base is in Europe, even just 1 or 2 customers, this regulation will more than likely apply to you. So ultimately we've got 2 years to comply, a deadline of May 2018. For those who are not compliant with data protection law at the moment, this could be a really big jump for you to make. So time to think about it now. I wonder, John, if it's a good time to do another poll?
I'm ready, absolutely. Here we go. Thank you. So great, thank you. That was fascinating. Here we go. I'm launching this poll, which is directly related. Here we go. Please tell us about it. Are you currently compliant with data protection laws in your home market? Please give us that information. We're interested to know. Are you fully compliant and up to date? Are you not sure and up to date, but not sure or no? Now let me give you feedback. 58% are saying yes, fully compliant. 15% are saying yes, not sure. 26%, 18% are not sure, but they think that they're up to date. So it's a bit of a mix. I'm going to be, here we go with the horn, it's ending. There we go, that's the end of the first poll. And this information, of course, by the way, will be available to you in 2 days' time. When we send it to you with the slide deck, you'll get this information feedback. Thank you.
Brilliant, thanks John. So with this in mind, today's webinar will introduce you to some of the main changes as a result of the regulation. These highlights will give you a feel for Europe's approach to the right to privacy compared to the US, for example, where the freedom of speech is enshrined in the Constitution. Europe takes privacy very seriously, as reflected in this new law. So we start with privacy by design. The essence of this change is that privacy should be considered at conception rather than later on down the line when you're already out to market and dealing with personal data. Essentially, companies must prioritize data protection and privacy, and it should be top of the list. Next, we've got consent. We know we have to get consent for use of personal data before now. This is just going to become much stricter. Consent must be freely given, i.e. opt-in rather than opt-out. It must be specific to a purpose, i.e. you need to know why you're collecting personal data and make that position clear to the individual. Consent must also be revocable, so if an individual changes their mind about your use of their data, they should be able to communicate this to you and withdraw their consent. Silence or inactivity will not constitute consent. We've also got this new category of sensitive data. Sensitive data is a specific type of personal data which goes one step further in identifying an individual. Examples being political opinions, religious belief, physical or mental health. Under this new regulation, genetic and biometric data will also be included. So you'll need explicit consent to process this type of data unless you can rely on an exception. In relation to children, parental consent will also be required for processing of personal data of children under 16. EU member states can even lower this to 13. So for international companies operating throughout Europe, this might actually require some analysis of which country operates on the higher or lower age bracket, a position we actually can't confirm until the 2-year transition period is complete, but certainly one to watch out for. Another key change, and the last on this slide, is the right to be forgotten. This provision emanates from a case where a man named Mario Gonzalez took a case against Google to have his historic debt issue removed from their search result for his name. He won the case and was actually ironically remembered as the man who earned us the right to be forgotten. So this principle is now enshrined in law. As such, if an individual wants their data erased, they can do so. Something to note if you're approached by an individual on this issue. Moving on to our next slide then, I guess the more onerous end of these changes. Our first point to note relates to breach notification. So data controllers will be required to report data breaches to their data protection authority unless it is likely to risk the rights of the individual in question. Notice must be made within 72 hours of the breach or the awareness of it unless an extension of time is justified. So essentially companies need to have a breach procedure in place. How do we know if there's been a breach? What should we do? Things to think about. The fines for non-compliance have increased quite dramatically. Whilst they can vary, you could be looking up to 20 million euro or 4% of global turnover. You can see these are huge figures. Going back to Europe's view on privacy, we take this very seriously. If anything, this is the main provision that will scare companies into action. Our next change then, there's no need to register with your local data protection authority as someone who controls, processes data. Now this doesn't mean sit back and hope these issues will never come your way. This is Europe's way of saying take responsibility for personal data, and as such the onus will be on the data controller to ensure they're compliant. The huge administrative penalty I just mentioned will act as an incentive, I guess, to do so. So the processors won't get away scot-free either. The controllers make decisions in relation to data, as you may know. Processors instead collate the data and send it to the controller to then make a decision. For a long time, as they didn't make decisions, processors were not directly liable. Well, under the new regulation, they are. As such, contractual arrangements between controllers and processes will need to be updated, documenting data responsibilities clearly. If this affects you, something to think about right now. So as you can see, the regulation sets out to ensure compliance as it applies to companies dealing with European citizens. For example, companies in the US, the detail should be given thorough consideration. I've given you the highlights, so now's the time to think about the changes you might need to make. So I guess we're on to the privacy shield. The slides mentioned Edward Snowden prior. His privacy regulations started the ball rolling on discussions on international privacy. Previously it was held that the US operated a national standard of privacy that was sufficient for data to be transferred freely to this jurisdiction. The related scheme was known as Safe Harbour. You may have heard of this fairly recently now. Case law has ruled that the Safe Harbour scheme was not sufficient to protect European citizen personal data. As such, the scheme was abandoned and a new privacy shield was drawn up. It's putting stronger obligations on US companies to protect personal data, to be transparent and give EU citizens redress options if their rights were breached. In April, however, this new scheme was rejected and as of this week received another blow, rejected by the European data watchdog on an issue of indiscriminate or inability to determine surveillance, who's surveilling the data, amongst other issues. So really, what does this mean? Transfers of personal data between Europe and the US are not automatically going to be adequate. Companies therefore need to consider their options to permit this international transfer. Some examples would be standard contractual clauses or binding corporate rules. If this affects you, start finding out about what you can do now. It won't be easy, and it is a grey area while the EU and US finalise an agreement that's satisfactory, but it's not going to be impossible. Going back to privacy by design, if you incorporate privacy into everyday life, this becomes habitual rather than a chore. So on to our next slides. What's next for us? Well, it's clear we need to know our data, and that's where we start from. We need to map out where our data comes from, where transfers occur, is it international, and if so, we need to get thinking about the GDPR. So data mapping helps determine where a breach might occur, whether your procedures can react quickly enough, maybe even consider conducting an audit. Somebody else can help you work out where you are and where you're trying to get to in terms of data protection compliance. Review your existing data protection policies, your codes of conduct, and your training. Ensure that these obtain obligations imposed by the relevant legislation. In the UK, that's the Data Protection Act, and you may also want to incorporate the GDPR. Also ensure you're compliant with the consent requirements. And I guess on to the next slide. Another thing to think about is identifying ways to demonstrate your compliance. Start having a paper trail about the decisions you're making in relation to data process, data protection training, and any updates you make to your security measures to show they're adequate. It might also be useful to appoint a data protection officer. Whilst this is not essential, this might help you incorporate privacy into the day-to-day running of your company. And lastly,
Michelle,
yes, go ahead.
No, that's right. This brings us, can we jump onto a poll directly relevant to what you're saying? Thank you so much. That was so interesting. Here's a poll, please. Is everybody ready? I'm going to launch this now. There you go. Do you currently have a data protection officer? So to please answer Michelle's question there. We rely on in-house expertise. We rely on external expertise. You're thinking about it. Okay. Or no. Right, I'll give you some feedback. We have 53% of people who say we rely on in-house, 15% say yes, we rely on external, 6% are thinking about it, that's interesting, and 26% say no. Well, there you go, there are some answers. As I said, you'll get this feedback, and here's the sound. That's the end of poll number 3. Michelle, back to you. Thank you.
Thank you, John. I guess just to finish on my area, US companies, I guess there's a few people on the webinar today that might be from the US, and I guess the practical idea to leave with would be spend the time now and work out a strategy for the next 2 years if you think this might apply to you. Understand your obligations under the GDPR and the privacy shield if indeed this gets finalised. If it doesn't go anywhere, the privacy shield negotiations don't look like they're going well, think about your alternative means to transfer data adequately. So, I mean, to conclude, there's a lot to think about here, and although we have 2 years until the regulation comes into force, you can see that there's a lot to do.
Michelle, thank you so much. That was, I mean, I've been scrambling to take all the notes, but I just want to reassure everybody we are sending out a recording of all this because there's so much information of what you've been giving, and very practical information as well in terms of your top tips on that and practical information. I wanted to pass over now to Stephan, really talk more about website compliance and how he sees it from his perspective and his main top tips. Stephan, if you're there.
Yeah, thank you, Susanna, and also thank you, Michelle, for that interesting information. So hello everybody, thanks for joining us today in our webinar. In the second part, I will talk a little bit about website compliance, which is quite challenging in the short time frame I got, but I will try to do my best to give you a general overview and a basic idea what you have to take into account if you're running a website which is going to European customers. So basically we can say there are like 2 principles which are very important, and the first principle is transparency. You have to tell the people who you are and what you do there on your website. So for this, the main important thing is the privacy policy. The privacy policy has to be a transparent, detailed, and understandable information about the identity of the data controller. So this would be the institution or the company who is using and processing the data for its own business purposes. The type of personal data which is collected by the website, for example, by ordering products, subscribe to a newsletter, or just by surfing and clicking on the web page. Here we got also the special topics about cookies, social plugins, tracking. We will come to that a bit later on. It is very important to tell the people also the purpose for which you are collecting this data. This can be also very different. It's very much depending on what you want to do, either if it's the marketing, the performance of a contract with your customers, providing the customer with individual commercial offers, or just the improvement of your website, or something like that. If you transfer the data to third parties or even outside the European Union, you have to tell this too. So this is also very important. Maybe it's also important for our audience here to know something about the term third parties, because this is something special we have in data protection law. So here we have no what we call concern privilege. So if your company is organized in an affiliated group and you're collecting data and you're transferring the data between the companies in the affiliated group, every company will be a third party. So also in this case, you have to put that in the privacy policy and tell the people about it. Also, you have to mention the rights of the data subject. What would be access to the data, correction of the data, erasure or blocking. Michelle mentioned the right to be forgotten before. And yeah, of course, the people need to have the opportunity to also contact the data controller then to get access to this right, and because of this, of course, they have to know who is in charge here. These are just some really basic and fundamental information which has to be in every privacy policy, but basically you can say that the content and details depend very much on your service, the tools you use, and also the usage of your data. So there's not really a template for a privacy policy. It's really individual and different from case to case. So from now, I would like to go on to the second part of our first principle. We are still at the transparency principle. This would be the imprint, or in Germany we call it Impressum. There are many different names for it actually. The important thing is not the name, the important thing is what has to be inside. And this is the information about the service provider of the website. The service provider is the one who is liable for the content of the web page. So before in the privacy policy, we had the institution who is responsible for the processing of personal data. Here it's just the company or institution who is liable for the whole content of the web page. So everything was at the web page, the whole content. And there we got various information. These are also the most important. It would be the name, of course, of the company, the corporate information, the name of the senior management or the directing manager, whoever's in charge, the legal form, the address, some contact information, public registers, and so on. Also here the minimum content differs between European member states, but I would say if you have this information here, then you are on quite a good way to have the most important facts you need for the imprint. All right, so then we can move on to the second principle. So in our first principle, we learned that it's that you need to be transparent, tell the people who you are and what you do. And the second principle would be the lawful collection and processing of personal data through the website. Of course, this is a topic you could talk like really for hours, but I will try to break it down as much as I can. So in the European Union, we have the principle that it's generally it's forbidden to process personal data as long as there's no law which allows it. or you have the consent of the data subject to do so. So there are several laws to give you a legal permission to process personal data. I just picked out one because it's one of the most important and most frequently appearing. It would be the necessity for performance of a contract. Obviously, when you have a customer and you want to perform a contract with him, so you want to send him some product or something like that, you need some information about him. You need to know who he is. You need to know his bank information, that you will get your money. You need to know where to send your product. So this would be an example when the collection and processing of personal data is allowed. But it's always important to consider some principles here. We have the principle of data reduction and data economy. That means that you are only allowed to collect and process the personal data you need for the performance of a contract. So nothing else. What is getting more and more important is, besides that, the consent of the data subject, because obviously there are a few laws which give you the permission to process personal data, but they apply only for certain cases. So if you have the consent of the data subject, of course you can do more. But since you can basically do a lot of things if you have the consent, the consent must fulfill certain requirements to be legal valid. Michelle mentioned that before, but it is also very important here when we're talking about website compliance, but because obviously you're collecting a lot of personal data here, and there are just a few ways to do this good also technically. So we already heard that the consent must be given explicitly. So we are opt-in. I guess most of you will know what opt-in is, but just to give you again the idea, you have this checkbox on your web page where the user can actively put a tick in it. So you have to opt-in. When the tick would be already inside and the user has to delete it, it would be an opt-out. That's not what what the law is demanding here. So we need the opt-in where the user is giving his consent active and explicitly. And furthermore, he must get a transparent information about the data processing. So sometimes it can be very short, so you can just put a text beside that box where you explain what happens to the data and if the user wants to give his consent or not. Most of the time, probably you want to do a lot of things with the data, and then you can just put something like, I have read the declaration of consent and hereby declare my consent to the processing of my personal data as stipulated there, but you have to see that you put a link directly there. So when at best a link to the word declaration of consent, and with this link the user can go directly to the declaration of consent where he is informed what will happen with his data and what you will do with it. The consent should be protocoled, because this is important, because you will have the burden of proof that the customer gave the consent. So good example is the double opt-in for newsletters. Yes, most of you know this. So you have the tick box, the customer ticks the box. After that, he gets the confirmation email with a confirmation link. He has, which he has to activate. So this is this will lead to the point that you have also the proof that the customer gave his consent, and also at what time he gave it, and so on. So this is basically a good method to do this. yeah, of course, the customer must be given the right of withdrawal at any time, and he also must be informed about that right. So as you can see, there are lots of things you have to consider if you want to have a legal valid content, and can be really hard from time to time, but it's not impossible. Also, you should really see that you have a safe data transfer if you process personal data via your web page. So your web page should use a safe HTTPS connection, or better said, a web page must use a state-of-the-art encryption technology like TLS, Transport Layer Security Protocol, the former known as SSL, Secure Socket Layer. And the storage of the data must either be in the European Union, or if it's outside the European Union, you have to see that you can fulfill the same standards of data protection which are in the European Union, also technically, of course. Yeah, this would be the slide, so we can go on here. So I would like to give you just a few examples of the first one would be the compliant use of cookies. Best thing to do here is to place a cookie banner on your landing page where the user again can actively give his consent for the cookie use. You should provide a link there to your privacy policy where you explain how your cookies work, what they do, if they are transferring personal data to third parties, and so on. Another important thing on web pages obviously are web page analytics tools, and there are really lots of them, but I just picked out Google Analytics because it's the most common and most frequently used tool. So these analyze tools also collect and analyze, often not all do this, but a lot of them, also Google Analytics does it, personal data, and they even might transfer it to the United States or somewhere out to the European Union. So here it is necessary to conclude a special data protection agreement with, in this case, with Google or the company, whoever company offers the Analyze tool, because they are processing data for you on your behalf. They're analyzing your personal data, they're processing it, so you need this contract to stay compliant here. And for the privacy policy, you can also use the statement or statements, different, which are provided by Google. They're quite good to be safe here. Next point would be social plugins, tracking, and marketing tools. All these tools which are really great for marketing. Nowadays you can do a lot of things with them. The marketing people of every company, they really love it. And yeah, then we come and tell them what the law demands here, and then they hate us for this. But I cannot say this very often, but especially in this field with the social plugins, the tracking, all the marketing tools, you have a lot of uncertainties because of the technical process, and it's just too fast, so that legislation and courts cannot really keep up with it. But what is quite clear is that as soon as these tools are collecting personal data, also IP addresses, so IP addresses, may they be static or dynamic, they are personal data too. So as soon as they're collecting this data, and might transfer it also to third parties, for example, Facebook, if you use Facebook custom audiences as an example. You need the content of the data subject to stay 100% compliant here. And
Stephan,
yeah,
that's so very interesting. I have to say, I've learned so very much. Thank you. Which brings us on to a poll. Look, we can launch into our fourth poll, please. If everybody's ready, directly applicable to this slide and what Stephan's talking about, I'm launching a poll. Here you go. Please, do you use cookie? Do you have social plugins in Google Analytics? I mean, I think we all do. And tell us, standard forms for cookies, social plugins in Google, do you have your own policies or do you only have a cookie policy? What are your thoughts? Are you currently thinking about it? Are you working on it? Now, 44% of us are saying here standard forms, 14% say yes, we have our own policies, 17% of the audience today, 20% are saying currently working on it, and 15%, 14% they're saying they're thinking about it. Those are some interesting numbers. There's clearly quite a bit of work to be done, and I think that we're going to have to say, here we go, the last of our fourth polls. There we go, that's the end of the fourth poll. Thank you very much. This information will be made available to you, and I hand back to Stephan.
Yeah, thank you very much, John. So just to wrap this up here, it really depends on what tools you're using and for what you're using at the end of the day. It can be difficult to stay compliant here, but it's not impossible. There are ways that it still works out to improve your marketing, and you can still stay compliant. At the end of the day, it's also a little bit of a question how much risk you're willing to take here. But so at that point, basically our work would start to advise you on all that kind of questions. All right, so we can move on, and just to summarize all that what I was talking about right now, we have a little example here of the web page of Greenpeace Germany. Greenpeace is a very dear client of us who kindly gave us the permission to use their website as an example. An organization like Greenpeace does have certain standards or principles, obviously, and one of them is certainly to respect the people's privacy and fundamental rights. So they're taking this whole data protection issue very serious, and for that their website is quite a good example. So at the left top you see actually the bottom of the actual page. It just clearly locates the privacy policy, and here we call authorship. Before we were talking about the imprint, or here you can see impressum. You might see the word Datenschutz at the left side. That's the privacy policy, and at the right side we have the impressum. So when you click on it, you come to either the impressum or the privacy policy. So you just have to have it somewhere at the bottom of the web page, can be also on the top. The important thing is just that it's clearly located and everybody can find it and see it. At the right top, we have just an example for the opt-in. So here the user can fill in some contact information. We have the box where he can tick the box and then press the confirmation button, the green one on the right side. Obviously, here it's just a little bit of information. It's just to send the user to get the content of the user to get some information material. So you can put the text right beside the box and get the content for it. All right. Yeah, at the right side, the privacy policy, left side impressum, and at the bottom detailed contact information. Please note the privacy policy and the impressum, of course, is just an excerpt. Yeah, that's not our privacy policy here. it's just an example and an excerpt. All right.
Stephan, thank you so much, and especially also this Greenpeace.de is a great example of how much good websites today have about protection, authorship, contact information, and respect of privacy. Now, I'm going to keep conclusions just very, very short because I want to leave a tiny bit of time for questions, I'm hoping. The conclusions I got from Intersoft Consulting and Briffa, from Michel and Stephan, very much were like, this is an environment that I can't ignore, first of all. It is an environment that is becoming increasingly defined and clearer from a European perspective, that it affects anyone dealing with Europe. If you're a U.S. company, if you're, whatever it is, it affects you. And that it, in many ways, from our point of view, and I'm touting their services here, I think, get good advice and get a good data compliance officer from the beginning. So I won't spend any more time. I just wondered, John, if we have any time at all left for questions.
Yes, we are running a little bit late, but absolutely we have to go for questions because there are some great questions. Do know, please, that we will be following up on these questions later, but by that I mean Michel, Stephan, Susanna will all be getting back to you, so please do know that we will respond to these questions, but let's jump straight into them. Michel, it says here, our company's developed a new product line they're about to launch, but they have not given much consideration to data protection issues. Should they wait, address data protection issues after launch? What's your view?
I guess it's a very commercial question, John, because they're almost ready to go and they don't want data protection issues holding them back. I mean, realistically, the message to take from this new regulation is it's privacy by design. So you can't just ignore data protection. They're at launch, they're good to go. There's nothing holding them back from launching, but they need to think about data protection at the same time. If they can't put it in place before, they need to put it in place now as they're going, as they're launching.
Michel, great answer. Thank you so much. Stephan, there's a quick one here for you from an American company, and it says we export to Europe, but as we're B2B, do we really need to bother with the personal data protections issue? Does that apply to them? Stephan?
Yeah, well, clearly yes. Of course, you might have less personal data in the B2B sector, but it's still there. For example, you have the names or email addresses of your business partner's contact persons. Also, if a company you're doing business with does have the same name as its owner, which is often the case when you have small family-owned companies, for example, you have personal data there. So, and of course, most of the website compliance issues I talked about today does still apply to you also. So yes, also in the B2B sector, you definitely have to deal with data protection.
Wow, I get it. Okay, thanks for clarifying that. Susanna, there's one for you here, please. Do I have to have a local website to have international marketing?
Thank you, John. That's actually sort of a double-edged question in a way. You can always do marketing from your domestic website. The problem is that it's not going to be really seen by your target export markets unless you have a fully functioning and optimized local website. So our view is if you really want to interact in the market and have an active and optimized and well-functioning marketing strategy, then you need to have a local platform, so a local website. So first prioritize your markets, make sure that you're targeting the right ones for you, and then say, right, how are we going to best get in there, build a website, how are we going to maintain, build a brand, market locally. Thank you, John.
Yeah, okay, thank you. I mean, I get that. And so out of these, I'm going to choose 3 more questions, just 3 more questions. Let's start off, Stephan. They're talking about one of your slides. They're talking about the difference between EU member states. I do remember that slide. And it says that there's a gold standard that we can apply that would satisfy everyone. Can you clarify, please?
generally spoken, the differences in the EU will get less because of the upcoming general data protection regulation, but it will never be all the same in the Union because the regulation has various opening clauses, so that the member states can bring their own legislation in. Of course, furthermore, it really depends on on what you're doing. Different business models mean different data protection solutions. So I wouldn't speak about one gold standard at all. No.
Okay, understood, and thank you. Michelle, actually, this is a question for you, which actually I wanted to ask myself. It's about this law doesn't come into force until May 2018. So how are we supposed to keep informed and up to date? What do we do in the interim? We're a US company, we're not necessarily kind of up to date with all EU news. Can you help us out?
Yeah, I mean, the key thing to take from today is you have to keep an eye on this. And the idea is not to try and implement a lot of change in April 2018 in view of May being the deadline. You need to sort of start thinking about this now, put some small measures in place, stagger the compliance over the 2 years and keep an eye what's going on. And then again, back to this privacy by design, it becomes habitual rather than a chore. So it becomes a habit in the office. You check, you know, data privacy law in the morning maybe, just in passing, and then you have a meeting on it midweek. You know, these are the sort of things you can do that become part of your daily routine rather than April 2018, panic, let's try and get compliant in a month.
Yeah, I mean, I guess that's it, isn't it? You've got to keep up with that. So jumping on, Susanna, this will be our last question as we move to close out. Susanna, what are the best social media platforms internationally and then for Europe? Social media platforms, relevant, there we go.
Obviously the very large ones are global platforms, you know, LinkedIn, you know, Twitter, even Facebook are used throughout the world, with some exceptions. I mean, China obviously has its own and doesn't really like Google. Google, for example, is just 2% market share in terms of search engine. But in terms of social media platforms in Europe, definitely go for the big guys. You know, the Twitters and LinkedIn and so on. But each European market will also have its own, and we try and interlace the two depending on how companies want to interact in the market and what they're actually looking for. So how deep down they want to go for. For example, LinkedIn, definitely in all your markets, but in Germany, there's a local or German equivalent of LinkedIn called Xing, which is also worthwhile, you know, interacting in if you're looking at the German market. That's one example. So both the top levels, those big global players, and then each market will have its own champions. Thank you, John.
Yeah, thank you for that. And I guess then, well, if I want to get on Xing, I can contact Stephan. I imagine that Stephan is there. Look, I want to thank you very much indeed. I'd like to, what I like to do as we get towards the end is, of course, share a little factoid. The factoid I found for today is that it took us just 15 years, starting in 1991. Do you remember? Well, perhaps those who do, 1991, there was one registered website. Today, we're at 1 billion registered websites. So there you go. In 15 years, 1 billion websites have been created. And therefore, what we're discussing today, well, I can tell you it's highly relevant. The growth of websites, localized websites, European websites requiring the kind of knowledge and understanding that we have been talking about today, that Michelle has shared with us and Stephan has shared with us. Well, clearly, it's all going to do nothing but grow and grow as online becomes more and more important. I remind you to please do know that this webinar was one in a series of webinars, and if you join us again in 2 weeks' time, guess what the subject is? Well, it's how to sell online in Europe. a very practical webinar in 2 weeks' time. That is on Wednesday, the 15th of June, how to sell online in Europe. Thank you again, and be aware that there is a survey that is going to appear on your screen as we close this webinar. Please do respond to the survey. It helps us to better serve you going forward. And do recall that on Friday, look in your email inbox and you will be receiving from us a copy of the slide deck and the recording. So I want to thank you all very much indeed for joining us. I hope that you have enjoyed the webinar. I hope that you have found the information useful and that there are lots and lots of takeaways to help you be even more successful online in Europe. I want to take this opportunity to thank Susanna for doing a great job hosting, Michelle and Stephan, experts on the subject matter as we successfully today delivered this. I'm going to now, on behalf of us all, here we go. Lots of applause there. This is applause for Michelle and Stephan. Thank you so much indeed as we go to close out today's webinar. What a great job. Thank you very much indeed, and goodbye.